Good afternoon, everybody. So today we will be discussing the rules for cash for keys agreements in the City of Los Angeles under the Rent Stabilization Ordinance, also known as the RSO. The information that's being provided is intended only for residential units located within the boundaries of the City of Los Angeles, and not for commercial units, and not for any properties that are located outside the boundaries of the City of LA. The first thing that an owner or a tenant needs to do is to confirm or understand whether or not the property is located within the City of Los Angeles, since those are the rules that we will be discussing today. The easiest way to know if the property is located within the city or a different city or even in the unincorporated county of LA area is to identify who the utilities are paid to, what company it's paid to. If it's paid to the Los Angeles Department of Water and Power, then the property is within the City of Los Angeles. If utilities are paid to any other company, for example, Edison, that is an indication that the property is not within the boundaries of the City of LA. You can further confirm if the property is found in the city by going to the website cimas.lacity.org. There you will be able to enter the property address, and if you do not have any search results, that's an indication the property is not in the city. You can also use this website to confirm if the property that is in the City of LA is subject to the Rent Stabilization Ordinance, the RSO. This is important to identify for the purpose of today's topic because only properties that are subject to the RSO in the City of LA are regulated by the rules that we will be discussing today. If the property is not in the City of LA, or even if it's in the city but not subject to the RSO, today's topic will not apply. When you search your property address on this website, you will see information on the left-hand side. There's a housing accordion, and within it, it will say RSO yes or RSO no. If it says yes, that means at least one of the units at the property is subject to the RSO. If it says no, that means none of the units are RSO. So regarding today's topic, the tenant buyout notification program, it is a law that became effective in January of 2017. So it's been in place for a few years now. The law amended the rent stabilization ordinance and requires that a landlord give tenants a notice of buyout rights prior to the parties signing a buyout agreement. Both the notice of the tenant rights and the agreement have to be filed with the Los Angeles Housing Department. And on your screen, you see an image of what the tenant rights notice looks like. It's 2 pages long. What the rules on buyouts cover is any written agreement where a landlord pays a tenant money or offers some other sort of consideration in exchange for the tenant to voluntarily move out of the RSO unit. So some names that you might see, or you might see in the documents, or the owner might discuss with the tenant are buyout agreements, cash for keys agreements, or voluntary vacate agreements. Those all mean the same thing. Those are all written agreements for the purpose of having the tenant voluntarily terminate the tenancy in exchange for compensation. The 2 documents that the law requires that the owner file with LHD are, as mentioned before, the RSO disclosure notice, meaning the tenant rights notice, and the buyout agreement itself. The disclosure notice is a notice that LHD has a template of on our website. We have it available in English and in Spanish, and an owner can download the form, and that's the only disclosure notice an owner can use when initiating negotiations with a tenant for a buyout agreement. The landlord must give to the tenant this disclosure notice before the owner asks the tenant to sign the agreement. The agreement, the disclosure notice has to be signed and dated by the tenant and the owner if both parties agree to an agreement to move out. If the agreement occurs, then both documents have to be filed with LHD within 60 days of the agreement being signed. The disclosure notice, we do include a hyperlink on the slides. So when you receive them via email, you'll be able to click on this link and it will take you to the disclosure notice itself. What the disclosure notice includes is information on the tenant rights. So there's a summary on the first page of tenant rights, including the fact that a tenant is not required to agree to a voluntary move out. It's voluntary. So a tenant can refuse to accept an offer to voluntarily move out. It also includes a link to the tenant anti-harassment ordinance, which provides additional rights and regulations whenever an owner is engaging in a buyout negotiation. This notice has as an example of the relocation chart on the right-hand side. These relocation amounts are just an example of what an owner would be required to pay under the law if the owner was evicting the tenant for a no-fault reason. So it's very important to understand that an eviction for no fault is not the same thing as a buyout agreement. The difference is that when a tenant receives an eviction notice for a no-fault reason, for example, owner occupancy, the tenant does not really have a choice. The tenant does have to move out if the owner follows all the procedures and pays the correct relocation amount. Whereas a buyout agreement is different because a buyout agreement is voluntary. The tenant has a choice. The tenant can say no, they don't want to agree to move out in exchange for payment. And so this chart gives tenants an idea of what relocation amounts an owner might have to pay a tenant if they would pursue a no-fault eviction instead of a voluntary vacate agreement. And this may assist the parties in negotiating what amount a tenant might be willing to accept in order to move out of the unit. The second document that's required to be filed with LHD is the buyout agreement itself. So for the most part, the municipal code does not regulate the terms of the agreement. Those are determined between the tenant and the owner. So for example, how many days a tenant will have to move out is not regulated by the city law. That depends. A tenant and an owner could agree to a standard 30-day period. They could agree to a 6-month period, a week, a year. It's whatever the parties agree will be the number of days that the tenant has before they have to move out. Likewise, the amount itself, although we do provide tenants information on what the relocation amounts are in case of a no-fault eviction, that is not the required amount for a buyout agreement. A buyout agreement can be any amount. It can be $1 or it could be $1 million, any amount that the parties agree to. The city law does have some regulations of a couple of terms in the agreement. One of them is that the agreement has to be written in the primary language of the tenant. Another one is that the agreement has to be dated and signed by both the tenant and the owner. A third requirement is that the agreement above the tenant's signature line has to include this language in bold that says you, tenant, may cancel this buyout agreement anytime up to 30 days after all parties have signed this agreement without any obligation or penalty. So that means if a tenant signs an agreement and the owner and tenant believe that they've reached a settlement and the tenant's going to move out, and the owner even files a copy of the documents with LHD. If the tenant is still within the first 30 days after they sign the agreement, they can still change their mind and notify the owner that they no longer wish to move out. And there will be no financial penalty against the tenant for changing their mind within the first 30 days. After 30 days, a tenant cannot change their mind unless the owner did not comply with the requirements of the city law For example, the agreement was not in the primary language of the tenant, or it was not signed and dated by everybody, or did not include this bold language that says a tenant can cancel within 30 days, or if the owner did not file both documents with LHD within 60 days after signing the agreement. If the owner doesn't follow these rules, then even if the tenant has signed the agreement, the tenant can cancel the agreement even after 30 days. So some additional tenant rights are that a tenant has a right not to accept the buyout offer. They have a right to obviously consult with an attorney and contact LHD to get information about the buyout rules before they sign any document. They have the right to cancel the agreement within 30 days or longer if the agreement, if the owner didn't follow the rules. Failure to follow the rules is a defense to an unlawful detainer. So if the owner ends up taking the tenant to eviction court because they did not move out after signing a buyout agreement, of course, the tenant and an owner, they're both recommended to seek legal advice. But the municipal code does say that a violation of the buyout rules could be a defense to an unlawful detainer. And the tenant also has a right to private action, meaning the tenant could take the owner to court for failure to follow the buyout rules. And there are, of course, limitations as to what amount a tenant could recover. Another tenant right is the tenant anti-harassment ordinance. So it's somewhat of a new law, I think 2019. Tenants in all rental units are protected from harassment. And this includes a landlord's attempts to coerce a tenant to vacate with offers of payments. Specifically for RSO units, it includes offering payments to a tenant to vacate their unit without providing the disclosure notice. So if you recall, I showed you an image of the disclosure notice that summarizes the tenant rights. So if an owner does not provide that, that may be evidence of harassment. So whenever an owner and tenant are engaging in negotiations, it is normal to go back and forth. That's normal. That's part of negotiating an agreement. But at a certain point, a tenant may become uncomfortable and not wish to continue negotiation. If the tenant feels like they're being harassed, then a tenant could contact the housing department and file a complaint. And this is how a tenant could file a complaint. One way would be to call our general hotline, and the phone number is located here at the bottom of the page. Another way a tenant could file a complaint is online. And the page that you see on your screen right now has a hyperlink to a site where there will be a form where a tenant can file a complaint for harassment or a complaint for an illegal buyout offer. And they would be assigned a housing investigator to assist them with this. And once you get these slides in the email, these hyperlinks will be active, so you'll be able to click on them from the slides. Now, if you're a tenant who received a buyout, but you're not sure if the owner filed it online, you can actually go on our website and look up the property and find out if there was a buyout filed. You would go to the website that's located on your page right here. It's property lookup. That's essentially what it is. It's a property lookup page. And you would enter the address or the APN. And once you enter the address and APN, you will see a variety of information about that specific property. But one of the sections is a tenant buyout notification program section. They will provide you the date, address, and amount of any buyout agreement that the owner has filed with LAHD. So in the example that you see here on your screen, there was a buyout agreement filed on June 1st, 2024, and the amount of compensation was $25,000. Now the address on the website is visible. You will be able to see the address of the property on the website. But for purposes of the presentation, we do not display the address. If you have questions about today's topics later on, or maybe even questions about other topics, related to housing, you can send us essentially an email using the Ask Housing app. And to use the Ask Housing app, you can sign up for an Angelino account. And this is the citywide. This is a citywide account where anybody can access all city services that are available online, including the housing department and any other department that has online services. So once you sign up for an Angelino account using your email address and creating a password, then you will be able to access many other services that are online, including the ability to use the Ask Housing app. And using this app, you'll be able to submit a question to the department by following this link and clicking the Submit a Question buttons. And when you do that, it will open up a form. And in that form, you will indicate your contact information, the property address, your question, and that email will be sent to the department-wide, and will be assigned to the specific program or section that handles the type of questions that you are asking. So this is a good resource to have because part of the response that you get may include hyperlinks to additional resources. You can also subscribe to the LHD newsletter, and there's a hyperlink for that on this page. But any LHD website that you're on, at the very bottom of the page, you'll see a button that says subscribe to our newsletters. If you just click on that, it will open up a form for you where you can sign up for our newsletter. And that's a good way to stay on top of any updates to the law. So there are a variety of ways of contacting LHD, including our general hotline, where you could also file complaints. You could RSVP for workshops on future topics. You can send us an email via the Ask Housing app, and you can sign up for our newsletter.